Hi everyone. So we'll get started now. Thank you for joining today for our Global Advertising Law Year in Review presentation. Um, my name is Jaclyne Reive. I'm a partner at Miller Thomson in Toronto and one of the co-chairs of our advertising and marketing group. I think today will be very exciting. We've got kind of a mix of legislative updates as well as some court and regulatory decisions from multiple countries. Some of these relate to working with influencers, greenwashing, consumer protection related changes, as well as packaging and labeling. So a little bit of everything. I think it will be interesting. Um, if you have any questions, please feel free to put them in the chat or into the Q&A spot, and we'll handle those at the end of the presentations. We're also recording this for those who cannot join today. In terms of our presenters, so we have Peter, who's presenting from Slovakia, Kim from South Africa. I'll be presenting with respect to Canada, Sebastian from Mexico, Baran from Turkey, and Kanu from India. So I guess we'll go ahead and get started, and I'll turn it over to Peter.
Hi, Jaclyne. Thanks for introduction. And hi, everyone from Slovakia. I'm going to talk about latest developments in advertising law in Slovakia, which is one of the EU member states. So I hope it will be interesting for you. So I would start with new legislation. As you may know, part of the legislation in EU countries is adopted at EU level, and then it is directly applicable in all countries in case of regulations, or indirectly applicable in case of directives which needs to be implemented. In 2024, Slovakia has implemented two important EU directives regarding consumer rights and consumer protection in general. One of the directives that we implemented is directive known as Omnibus Directive, which was adopted in 2020 with the aim to reinforce consumers' rights against merchants, including e-commerce merchants. The other directive that we implemented is directive regulating so-called collective actions. Well, the term collective actions may be well known to everybody in states or in other countries, but here in Europe we have different system of legislation, and therefore it is not so common. In fact, in Slovakia, it is the first time when the consumers will have right to file collective action against a merchant who is breaching consumer protection laws or even advertising laws. So I think it is very useful tool for the consumers, as very often the consumer claims are minor and the costs of legal proceedings are high. So with these collective actions, consumers will have, I think, better chance to enforce their claims against big merchants. If I come back to Omnibus Directive, usually when the EU law is implemented, it is implemented through amendment to existing laws, but this time Slovakia took opportunity and adopted brandly new Consumer Protection Act, and it basically regulates whole universe of consumer relationships and brings a lot of news in our system. But I would mention only 3 points here. First is the new obligation to disclose the lowest price during past 30 days whenever a merchant is selling products or services with a discount. This way, the consumer can make his or her own assessment as to whether it is really a discount or just a marketing tool. The second point is reviews. Not only the new law states that false reviews are considered as unfair commercial practice, which is prohibited in European Union. But it also imposes new obligation on merchants who must take appropriate measures to verify whether the reviews are made by real consumers who actually purchase the product. Third point that I would briefly mention is penalties. We have new system of penalties. The penalties will be imposed based on turnover of the merchant, and maybe impose up to 6% of the turnover and maximum amounts of 200,000 euros. This means that the bigger players will probably be sanctioned with higher fines compared to smaller businesses. The other topic that I would briefly talk about is influencer marketing. Since 2022, we have had a code of influencer marketing, which was adopted on self-regulatory basis. And one of the main points of the code is correct labeling of collaboration between influencers and brands. In 2024, two organizations behind the code, namely AIB Slovakia and ADMA, carried out the survey with a sample of 75 influencers and a review of more than 3,000 posts. The conclusions are that there were 22% commercial posts of influencers, and out of these 22%, 77% of these commercial posts were labeled as advertising. I think this is very nice number compared to a previous one, 68% in 2023, and especially compared to previous years where only very few influencers were labeling their posts as commercial collaboration with a brand. On the other hand, there's only 26% of influencers who had all their posts labeled correctly, so there is still room for improvement. Okay, now I would like to mention some interesting case law from Slovakia. First, advertising of betting company Tipsport. During the ice hockey championship in Prague, this company came out with an advertising featuring two famous hockey players. You might know them, Tomáš Tatar, Slovak hockey player, and David Pastrňák, Czech player. And the ad itself was actually very funny, as it was showing these two players playing golf and driving a golf car in very specific manner. But the problem was the main advertising claim, which was all it takes is to begin. The ad was assessed by arbitration committee of the advertising council, who concluded that the advertising was giving the impression that betting is a form of leisure activity that brings only fun and intense positive experience, and at the same time it was downplaying negative impacts of gambling. The other case, it must be said that not only merchants breach advertising laws, but also law firms. In 2024, there was a complaint against a law firm whose partner made a video in which he was inviting clients to contact him in case they had dispute with a bank or other financial institution. And he was claiming that these institutions and banks, they have many mistakes in their contractual documentations, and he would defend them against banks based on these mistakes. This advertising actually sounded like encouraging non-compliance with contractual obligations towards banks. So now it has been assessed, or it is assessed by Slovak Bar Association. In 2024, there was also an interesting decision by the Supreme Administrative Court of the Slovak Republic regarding nudity in advertising. I'm not going into detail, but the key takeaway from the decision is that good manners must be judged more strictly in the context of advertising as opposed to art, for example. And also that women and men should never be portrayed as a commodity in advertising. Last topic that I would like to talk about is personalized advertising in EU. As you may know, since 2018, there is EU regulation on data processing. This regulation is known as GDPR, and this regulation requires that whenever someone processes personal data, it must have appropriate legal basis for such processing. Since 2018, Meta was arguing that they used contractual obligation as legal grounds for processing data for personalized advertising. But after a few fines, they changed the argument and they said that they were processing the data based on legitimate interest. After another penalties, they changed the strategy, and from 2023, they had the strategy which is known here as pay or okay. Basically, they gave option to users to opt out of personalized ads by paying a fee for the services, which was around 240 euros per year, or just to use the platform for free, but with personalized ads. In August 2024, European Data Protection Board issued opinion about this strategy, and basically this opinion concluded that that such concept was probably not based on proper and freely given consent as it is required under GDPR. So Meta had to really think of another strategy, and it is expected that they come with new strategy for 2025 based on less personalized ads, but more visible ads. Basically, as far as we know, they should process only location data and data about date of birth for personalized advertising. But on the other hand, they would use more aggressive advertising. They would use full screen advertising that cannot be skipped. Very soon, there were voices suggesting that there was a dark pattern, which is also prohibited in EU. So let's see how Meta will get out of this.
Thanks, Peter. Very interesting to see, and I'm looking forward to see how they end up proceeding for 2025. The one other thing that you mentioned that I thought was really interesting was with respect to the influencers. Basically, like now there's an increased number having the proper ad disclosures or disclaimers. So versus like 26%, I think you said, having fully compliant ads. So I thought that was interesting, and it looks like maybe over time we'll continue to see that kind of increase, and especially with like the new focus on consumer protection and everything too. So thank you for that. All right, we'll move over to Kim for South Africa.
Thank you. Hi everyone, I'm Kim Rampersadh, and I'll be presenting today on South Africa regarding advertising developments. So to kick us off, I'll start with legislative developments. The first development that I'd like to discuss relates to plant-based meat alternatives. So in order to place this development in context, I have to provide you with some history. In 2022 in South Africa, the Food Safety Agency issued a notice for the seizure of plant-based meat alternatives or meat analogs from the retailer trade in South Africa on the basis that there were certain indications or descriptions being used in relation to these products that were typically and originally used in relation to products of animal protein origin or meats, and that their use would give rise to confusion in the trade. Naturally, there was litigation by the manufacturers of plant-based meat products for an urgent interdict or injunction to try and restrain that seizure, and they were in fact successful. Simultaneously, an appeals board that's devised in terms of our Agricultural Products and Standards Act also indicated that these regulations relating to processed meat and meat products specifically excluded plant-based meat alternatives or meat analogs. It also directed at the time that separate regulations needed to be created in relation to plant-based meat alternatives. In the meantime, the ensuing litigation continued and was finally finalized this year. It resulted in the notice by the Food Safety Agency being overturned finally, and the court also directed that there be further regulations and separate regulations devised in relation to plant-based meat alternatives. Despite this, a mere 9 days after that decision had been issued, we saw an amendment published in relation to these regulations dealing with processed meat, and the amendment saw the deletion of the exclusion of meat analogs from the ambit of the regulations. As a result, we're in a position of flux because we do not have additional regulations drafted in relation to plant-based meat alternatives. And while this beef continues, the plant-based meat alternatives continue to be available in South Africa and are being consumed. An additional regulation that was published relating to alcoholic beverages by our Department of Agriculture, Land Reform and Rural Distribution is the regulation relating to beer in particular and alcoholic beverages. The reason why it is so far reaching in relation to beer is because of the history of beer in South Africa, specifically where beer was initially categorized as a foodstuff and dealt with as a foodstuff. It was only brought under the ambit of the Liquor Products Act by way of an amendment in terms of that act. And now this regulation seeks to affect specifically the constituency of beer, including African traditional beer. It specifically states that African traditional beer needs to have at least a 4% solid containment of materials either derived from grain or meal, whereas in respect of beer, it needs to be at least 35% derived from malted wheat or malted barley. And as a result of the prescription in relation to constituency, beer has now been placed into specific designations. In addition to that, the regulations prescribe that these designations need to be indicated on the labels of the beer products, in addition to other material like, for instance, the drinking message relating to underage drinking. Naturally, there are cost implications involved, and it's anticipated that we might see some challenge to these regulations. In addition, in South Africa, there's anticipated legislation. This legislation specifically is anticipated in relation to the commercial cultivation, use, and sale of marijuana or cannabis, and not for medicinal purposes. Again, I need to provide you with some context. So in 2018, our Constitutional Court issued a decision that effectively saw parts of our Drugs Act and Drug Trafficking Act declared unconstitutional, and this was done in order to make way for the private cultivation and use of marijuana and products derived therefrom in a homestead. It also directed at the time that there be legislative reform in order to give effect to the decision and align what was happening in trade with the law. As a result, we then saw the Cannabis for Private Purposes Act signed into law this year, and it did in fact make way for the private cultivation and use of cannabis or marijuana in a homestead. The exclusions being that you could not do so for commercial purposes, so no commercial trading, and also you're not allowed to use in the presence of a minor. Despite that, though, the law still is not fully aligned with the factual position in South Africa, largely because since 2018, many South Africans misinterpreted the decision to mean that they could use cannabis or marijuana freely other than for medicinal purposes. In addition to that, we saw a spike in high-grow clubs, followed by raids and seizures and arrests by our police. As a result, our government, naturally, they also saw an opportunity economically and drafted what we refer to as the National Cannabis Master Plan. And now we're anticipating legislation that will result in the commercial use, cultivation, sale, and even promotion of marijuana and products derived therefrom. in trade. Obviously, this comes at a trying time in South Africa as well, because we also have legislation on the other hand that's trying to restrain advertising and sale to a degree of tobacco and electronic delivery systems. Specifically, we're seeing the introduction of plain packaging, and it's likely that that act will be passed. Cases of interest in South Africa. So these are cases that have been dealt with by our advertising watchdog or the Advertising Regulatory Board in South Africa. The first case is the case between L'Oreal and Nutriwoman. It was pretty topical in South Africa because it related to copycat packaging, and we saw a first instance decision before the ARB as well as an appeal. So briefly stated, L'Oreal is the owner of the CeraVe product that you see there in the first line. That's an entire range with the packaging. And Nutriwoman owns the Dermacare range indicated below there. And L'Oreal instituted or filed a complaint against Nutriwoman on the basis that its packaging constituted an exploitation of its advertising goodwill, as well as an imitation of its packaging in relation to the CeraVe range. L'Oreal led extensive evidence relating to sales and advertising in order to prove its advertising goodwill, and the ARB tended to agree that it did in fact have an advertising goodwill and that Dermacare had imitated its packaging. Nutriwoman was dissatisfied with the decision and then went on to appeal before the Appeals Commission. This is an excerpt from its papers. In attempting to discredit the initial decision, Nutriwoman alleged that L'Oreal could not have established an advertising goodwill because it had only been trading since 2022 in South Africa. It also attempted to claim that there could be no risk of confusion because there were many other products in the trade that used a similar brand architecture. It relied on the fact that the products contained different or distinguishable trademarks, being Dermacare and CeraVe. It also went insofar as to state, and this is my personal favorite, that there are dupes that are commonplace in the market and that there is no law against dupes appearing in the market. Naturally, the ARB disagreed and stated that L'Oreal had indeed shown that it had an established advertising goodwill, despite the fact that it had only traded for a period of approximately 2 years. It considered its market share. It also considered that the products had a unique combination of ingredients that had come to be exclusively associated with L'Oreal and which dictated the appearance of its packaging. And insofar as the overall similarities were concerned between the goods, it stated that there were too many for them to be coincidental. In addition to that, insofar as the dupes appearing on the market was concerned, the ARB said, whereas that might be the case, it does not mean that manufacturers have free rein to exploit the advertising goodwill or imitate the packaging of another. Also in South Africa, we had an historical case by the ARB. It was our first greenwashing case that was dealt with. It was specifically dealt with in terms of the Code of Advertising Practice. Appendix G of that code typically deals with environmental claims. Although this complaint was not specifically introduced in terms of Appendix G, there is other legislation in South Africa that also affect environmental or green claims, such as our Consumer Protection Act, as well as the common law dealing with unlawful competition and standards that have been approved by the South African Bureau of Standards, but those did not come into play here. So briefly stated, in this case, Total Energies had partnered with the South African National Parks in order to conduct a campaign under the hashtag Fuel Your Experience, and the intention was to get additional tourists and South Africans to visit the South African National Parks. It then published this excerpt on its website where it stated, and unfortunately it's too small, my apologies, but it stated on Total Energies website, "We are committed to sustainable development and environmental protection." Fossil Free South Africa, which is an NGO campaign in South Africa, filed the complaint on the basis that that specific statement was misleading and false. In supporting its complaint, it led evidence regarding the carbon emissions of Total Energies, the fact that it is involved in fracking and mining of fossil fuels on the Cape Coast of South Africa, and that its business interests generally are contrary to sustainable development. The ARB considered the decision and found that considered the complaint and found that whereas Total Energies had in fact partnered with South African National Parks for an extensive period and had contributed to the preservation of our natural heritage, its business interests were indeed contrary to sustainable development. Therefore, it could only say that it was committed to environmental protection and not sustainable development. A further and final interesting development that happened in South Africa towards the end of October was that the ARB announced that there's now an access point between the ARB and Meta, allowing for communication of decisions made by the ARB to Meta and for better implementation on the social media sites that it operates and owns. I cannot comment on the efficacy because it is still very new, although we are hoping that we see added effectiveness of the decisions received from the ARB, especially where its jurisdiction is typically limited to members and to people that submit to its jurisdiction. Thank you. That's it from me.
Thank you, Kim. Very interesting because I feel like there's been quite a few developments this past year in South Africa, and the one that stuck out the most to me was the legalization or the potential legalization in future of cannabis for commercial purposes, only because it tracks well with Canada. So I'm interested to see what happens there as well. Okay, so with that, I'll present now with respect to our changes in Canada. There's also been quite a few, but I'm going to focus on 3 areas in particular. So changes to our Competition Act with respect to greenwashing, some drip pricing changes as well, and then updates that have happened in the province of Quebec. So with respect to greenwashing, which, as you all are probably already aware, greenwashing is when you're making an environmental claim, but you don't necessarily have proper substantive proof to support your claim, and so it becomes misleading. So greenwashing has always been prohibited in Canada. Typically, it was dealt with under our Competition Act under the general false and misleading advertising provisions. About maybe 2 or 3 years ago, our Competition Bureau used to have this very lengthy guidance document that talked about environmental claims, which was then archived with a statement basically saying that this is no longer the Competition Tribunal or the Competition Bureau's position on environmental claims anymore. And so as a result of that, they then replaced it with kind of like a 1-pager that had maybe 5 things on it as to what how we're supposed to look at environmental claims. And then finally, most recently in June of 2024, the Competition Act itself was amended to add in specific provisions dealing with environmental claims. So it's basically has been codified now. So it's split up into 2 provisions. So one of those is what we would call the product provision, and the other is the benefit provision. So the product provision basically says that if you're making claims about a product's environmental benefits, they have to be supported by adequate and proper testing. So again, not very different from what the rule was before. And then the benefit provision says that for claims about the environmental benefits of a business or its activities, so we're looking more at business interest or services related claims, those need to be adequately substantiated by adequate and proper testing using an internationally recognized methodology. And so kind of one of the differences here with what the legislation used to say is that you can now kind of violate these provisions even if what you're saying doesn't necessarily influence a purchasing decision or product performance, which would be part of it from the analysis of general false and misleading rules. The Bureau then went on to issue guidelines to help define adequate and proper testing for claims related to a product's performance, its effectiveness, or its length of life. And basically, these are testing has to be conducted before the claims are made. It has to be carried out under controlled conditions, and it has to substantiate the overall impression that's created by the claim. Again, not very different from what would typically apply for general false and misleading claims and having testing and support for those. However, with respect to the internationally recognized methodology, it's still very unclear to us as to what that's actually going to mean, and we're waiting for the regulator to publish guidance on that as well, because there really isn't a universally adopted standard for environmental testing. So it's kind of hard to figure out at this point as to what that's actually going to mean in future. And before I move over to drip pricing, I'll just flag that there's been a couple other changes to our Competition Act as well. So you can now have what we call collaboration agreements between third parties where the goal is to provide environmental benefits as long as the agreement wouldn't result in something that's preventing competition or trying to lessen competition in the market. And then another really big one is our administrative monetary penalties for false and misleading advertising have been significantly increased. And when I say significant, I mean like extremely significant. The penalties are they're quite high now. For a corporation, the penalty is the greater of 10 million Canadian. and 3 times the value of the benefit derived from the deceptive conduct. Or if you can't figure out what the dollar value would be from that, then 3% of the corporation's annual worldwide gross revenue. So not small pocket change. And then one other change is that private parties can now also initiate proceedings in front of our tribunal, versus before it was a little bit of a different rule and you couldn't just have kind of like a private right of action. There does have to be a public interest reason for it to be looked at by the tribunal, but that's kind of a big change in the area. So next we'll talk about drip pricing. So again, this is one where drip pricing has technically always fallen under our false and misleading advertising rules, but it was recently codified. And so now drip pricing is explicitly recognized. And here we're talking about when a company advertises prices that are not attainable due to mandatory charges or additional fees, other than taxes. So this could be something like an administrative fee that is attached to an online booking. Which then brings me to the Cineplex case that's referenced on the slide here. So this was kind of our first case that we saw in Canada testing these new drip pricing rules, where Cineplex, which is our one of our movie theater companies in Canada, basically they were selling tickets online, and there was an investigation brought with respect to the way that they were doing their online booking of prices, and there was apparently like an online booking fee that was attached like as an administrative fee to what the consumer would actually pay. But you couldn't actually see the breakdown of that fee unless you scrolled down to the bottom of the page. But the website was set up in a way where it didn't encourage scrolling. And so it was the whole context of the website wasn't looked at. They just looked at everything kind of like above the fold. And so that was kind of a first test, and as you see, the penalty was quite high in that particular case. But one of the other interesting things that came out of this was that the tribunal looked at our general impression test. So for a number of years, it's always been what a credulous and inexperienced consumer would be considering when they look at an advertising claim. And so the idea is that's somebody who's not going to be reading between the lines. They're just looking at it. They're in a hurry. The tribunal stated that this shouldn't be accepted anymore as the standard for the general impression test. We should be looking at what an ordinary consumer would be considering when they're looking at that product or service, the nature of the representation that's being made, the characteristics of the members of the public to whom that representation is made, and the particular circumstances of the case. So that's quite a difference from what our test previously was. So it will be interesting to see how that kind of develops over time. And then with respect to Quebec, so Quebec recently overhauled its French language rules as well as its privacy legislation. And so some of these changes have been coming into force over time since 2022, 2023, depending on the legislation that we're talking about. And they now just most recently published their final regulation with respect to French language laws. And so this will apply to anybody who is selling a product or service to people who are based in Quebec. So even if you're not based in Canada, this will apply if you're selling to Quebec. Or if you are physically located in Quebec, these rules will also apply. So the ones that I think are most relevant for today, there is a trademark exemption. Actually, I'm going to back up for a second. Basically, the new rules say that anything that you have in Quebec needs to be translated completely into French. So there was supposed to be an exemption for trademarks where if you had a trademark that was registered in a language other than French, and you didn't also have a French version, then you didn't need to translate that trademark. When this was published in draft, the industry kind of got really angry about it and said, well, what about recognized trademarks, whether they're registered or not registered? Because right now it's taking about 2 to 3 years to actually get a trademark registered, so it's quite an onerous process to become compliant. So this final rule kind of backtracked on that and said, as long as it's recognized, it's fine. You don't need a translation for it. So that was kind of one big development. In terms of packaging and labeling, other than just the trademark part of it, if you have a generic term or product description that's included with your trademark, that has to be translated into French. So you can see I'm not sure how well you can see it, but the best soap description there, anything that even if you registered that with the trademark, you still have to translate that into French. And so you can see on the right what it should look like with the translations. The only exceptions for things that don't need to be translated are the name of the company, the name of the product as sold, and designations that are related to the origin or anything distinctive from a cultural perspective. Those are not considered to be generic or descriptive terms, so they don't need to be in French. And as you can see from the slide, there is a bit of a grace period that applies in certain circumstances in terms of compliance with those rules. If you're doing business in Quebec, there's also been changes with respect to actual signage. French needs to be markedly predominant, which essentially means 2 times as large as the other language that's on your signage. And it needs to be, like, if it's visible from the outside, then this rule applies. If there's dynamic signage, then the text in French needs to be visible for at least twice as long as a text in another language. And again, so you can kind of see some examples on the slides of what's permitted versus what's not. And then finally, contracts of adhesion. So these are contracts that are imposed by one party. So your standard form agreements, standard terms and conditions. Essentially now you not only need to have it translated into French, but the French version needs to be presented at the same time as the English version. And whether it's a consumer or a business, the counterparty needs to have the option of choosing if they want to have a language other than French apply. And if they pick French, then that basically means everything, all communications going forward need to be in French. There are some exceptions to this rule. What we're calling it the relations outside of Quebec exemption, where basically if you are a party who's not located in Quebec, then there's a little bit of a gray area here as to whether or not you need to comply with that full translation and presentation rule. But typically what we're seeing is if you're dealing with consumers or if you're dealing with like physical goods in the province of Quebec being delivered, rather than things like, let's say, software as a service, the exception is more likely not going to apply and you would need everything to be in French. But again, there's no guidance on this and it's so new that we don't have any cases that are really talking about it. So we'll see what actually ends up happening. And I won't speak too much about our privacy law changes, but I will mention that Quebec completely overhauled their privacy legislation a couple of years ago, and now it is fully in force. And so the rules are a little bit different than the rest of Canada. So if you're collecting personal information from somebody located in Quebec, definitely keep in mind as to whether or not you need to do some kind of compliance review in that regard. Okay, and with that, I will turn it over to Sebastian to discuss Mexico.
Perfect. Thank you. First of all, I would like to thank everyone for being here and for inviting me. I'll talk about, I don't know if you can see Mexican presentation because perfect, amazing. I'll talk about the Mexican developments this year. So in recent years, Mexico has faced many changes and updates regarding advertising. Our new governments have dedicated a good amount of their time trying to regulate advertising practices. Among the most important developments are the Influencers Guide by the Consumer Protection Agency, which seeks to regulate the information and advertising content that influencers publish on their social media platforms. These guidelines state what is considered as advertising, for example, reference or mentioning products or services on their social networks, if the influencer is invited to an event or a trip and shares her experience, if the influencer receives any benefit that is not an economic, and share his experience, for example, restaurants, or if they receive clothes. So that are some of the considerations they are including in these guidelines. And so the authority makes some suggestions in a very simple format. It's almost a PowerPoint presentation to be considered and followed by these influencers when publishing information that is considered as advertising. And some of these information, some of these suggestions are the inclusion of hashtags, the inclusion of also of warnings for the safe use of the product or service, as well as restrictions or provisions for the safety or health reasons for consumers. the information that these influencers share must be true, verifiable, and clear. And they need to check if the recommended product or service they're doing in the advertising complies with specific regulations. It's important to consider that this document is not binding. However, these suggestions help the influencer avoid incurring impossible assumptions of generating abusive or misleading advertising, which would lead to consider violations to the law, and that could lead to sanctions. It also, of course, helps the consumer to know that what they are watching is an advertising. And next, we'll have the influencer advertising roles and responsibility guidelines of Mexican FDA. It's important to mention that the advertising of food, beverage, cosmetics, health services, food supplements, and beauty products is specifically addressed in the regulation of the General Health Law on Advertising. However, the Mexican FDA issue a series of additional guidelines with the objective of informing about the roles and the responsibilities of the parties involved in the advertising. These guidelines are mainly aimed to content creators, advertising agencies, and companies to combat the publication of incorrect or out of context information in social networks. And to, of course, to ensure transparency and the protection of public health, the guide requires all advertised content to include warnings about the risk of using or consuming the products or services that are being advertised. In addition, it's mandatory to display the advertising permits by the authority. In case of non-compliance, any person may file health complaints, and both content creators and advertising may help liable for not including this type of information, and they could be included in the list of irregular advertising. Some of the additional responsibilities of the parties involved may include not to attribute preventive or curative qualities to the products, not to encourage the use of the product with false properties, or recommend the use of others than they indicated by the manufacturer. Then we have probably in the next slide, please. No. In the other one. Yeah, that one. Thank you. We have the Mexico City outdoor advertising law. The purpose of this legislation is to regulate the installation, distribution, maintenance, and removal of advertising in public spaces and on properties visible from the outside. This law is only for Mexico City, but it's start to being like the first step for other legislations. The main objective of this law is to reduce visual pollution, avoid risk in private properties due to the installation of heavy structures, and it prohibits sexist and racist messages. It also prohibits the use of, for example, drones or inflatable for advertising purposes, advertising in areas of ecological conservation or environmental value. For this, they have created a register of companies and advertising, but they have a very important backlog. They started last year, but till this day, we have a case that we haven't received the authorization for being in this list. So imagine how long it has been since this was published to getting a permit. Finally, we have the regulation to the General Health Law regarding advertising. This legislation purpose is first to make an informed decision for the consumers of what are you buying, and to know what products that you are acquiring are a risk to your health. We previously have a regulation regarding this, but only on product packaging. However, this new document gives it even more strength and includes provisions on the use also of materials in advertising and not only in packaging. This regulation has the purpose of indicating when the product contains excess of nutrients or critical ingredients such as calories, saturated fats, trans fats, sugar, sodium, and it also prohibits using, for example, children characters, cartoon and celebrities on advertising materials. Next thing. Next one. Yeah, perfect. So I want to, no, the other one. Sorry, it's going a little slower. Perfect. So I want to talk about two interesting cases that happened this year in Mexico. The first one is about the leveling problems related to the new regulation of the legislation that I talked about just now. And the thing is that there's a lack of a secondary instrument that clearly establish new obligations and provision on advertising derived from this legal framework. Therefore, food companies are trying to change their formula on many products so they don't need to add these stamps, or they are able to use their characters or celebrities and to avoid these restrictions. And another very important case that there's a lot of handling here at the firm is that the Consumer Protection Agency is going against a lot of influencers based on the influencers guidelines. Although it's not binding, Profeco has initiated actions against influencers for issues relating mainly to technology products based on the problem, based on the influencer guidelines, of course. But the problem with the document is that it's very, very simple. So it lacks a lot of relevant information. For example, what should be considered as an influencer, who should be responsible for the content published, permission, among others, which makes complicated for the influencer to know if the content, even first of all, if they are an influencer, but because we don't have like a parameter from how many of followers you are considered an influencer by the authority. So that's some of the cases that we're handling here in Mexico about the laws I've just established. And the last slide, it's about what should we expect in Mexico for next year. As probably many of you know, we're hosting with the US and Canada the FIFA World Cup in 2026. So it's going to be very interesting to see how the authorities react to all the advertising areas that will need to be attended and addressed as a consequence of hosting an event of this magnitude. So we'll probably going to see a lot of legislative changes, probably new laws regarding ambush marketing or advertising practices that are going to be involved in the FIFA World Cup. And finally, we'll have a new transparency law in the acquisition of media spaces. We used to have a past law a few years ago, but it was canceled because the law was intended to regulate the acquisition of advertising spaces, and it affected media agencies and advertising. But once again, the law was pretty simple. It has a lot of faults. So some information has been shared in the past few months that the intention of the new government is to publish a new one correcting these mistakes, and it will be very important to keep updated in this matter. And that's everything from my side. Thank you, guys.
Thanks, Sebastian. I think it's interesting that some of this is coming like just on time for FIFA, and to see what will also be coming soon for FIFA, or just in time for FIFA. Not all for FIFA, but yeah, interesting. Thank you for that. We'll turn over to Baran to speak about Turkey now. Oh, I think you're on mute right now.
Yeah, I was just saying hi everyone. I'm from Turkey. It's a pleasure to be here and welcome. In 2024, there have been significant developments about advertising law in Turkey. I'm really excited to share these updates with you. Let's start with amendments to legislation as the first step. This year, next slide. Yeah. This year, administrative monetary fines for advertisements were significantly increased. It is now up to 23 million Turkish liras. It's really big. Secondly, settlement remedy is now possible for against administrative monetary fines imposed by the advertising board. This is an administrative remedy which is highly and really effective. In this remedy, you can negotiate with the ministry for the actual amount of the fine to be paid. And three, the advertising board regained the power to access blocking to online content. This power was cancelled back in 2023. It was enacted again, but this time as guided by the Constitutional Court. Let's speak about some more interesting topics like dark patterns. I know dark patterns are broad area, but I will specifically speak about dark patterns in terms of misleading website designs. Simply, dark patterns are some sort of unfair commercial practice under Turkish law. As an example, by its definition, dark patterns can be manipulative elements that negatively affect consumers' decision-making or aim to lead them to make decisions that they would not make under normal circumstances. The advertising board has recently rendered numerous decisions which are focused on dark patterns. The focus was mainly on website designs and was mainly for subscription services and plans. Now let's move on to some examples related to dark plans. On the next slide, we will see an example, a decision regarding YouTube Premium website and subscription plan. There are individual, family, and student plans as options. The individual plan is pre-selected. It comes pre-selected to consumers. Also, the option to decline 1 month free trial was only presented as an X mark at the top right corner, and it's just very small, so consumers cannot easily see it, etc. This was not located or designed in the same way as the accept button. This is something that advertising board requires for not being misleading and for these website designs not to be a dark pattern. Ultimately, the advertising board ruled that pre-selected individual plan is directing consumers' choice. Additionally, the decline option makes it more difficult for consumers to easily reject the offer. Eventually, the board decided that website design was dark pattern. At the next decision, which is about Spotify, we will see that on the website, in order to accept 1 month free trial offer, users were required to provide credit card details. Additionally, account deletion was more complex than creating an account. Advertising board reviewed this in detail. The advertising board at the end concluded that free trial offer is misleading because it should not require credit card details. And the website design was found to be a dark pattern, an example of dark pattern. Another hot topic, without any doubt, is influencer marketing, but in previous years we talked about much about influencer marketing. I will just focus on certification program. Actually, this is not a typical certification program because in Turkey it is generally permissible to advertise on social media as an influencer and no legal requirement is needed. But this is type of a training which was initiated by the ministry advertising board. Advertising board is within the body of the ministry, and advertising self-regulatory board. This Since this is a training, it was not a requirement to attend it, but the number of the attendants was big, it was huge. It was organized to increase awareness and to ensure that influencers act responsibly. It was just last month in November, and the training was great according to statements of influencers who attended. The participants as influencers expressed that the content was highly beneficial and the content helped them to have a better understanding of the regulatory rules. The last topic I would like to talk about is alcohol advertising, particularly on social media. In Turkey, under Turkish law, alcohol advertising is strictly banned on any media, including social media, TV, radio, outdoor, etc. Due to strict bans on alcohol brands, on alcohol advertising, alcohol brands, the companies might lead to their promotion through alibi marketing or through social media, where the investigation of the advertising board might be less effective. The first decision on the presentation is about a YouTube video. In the content, it was helped by the advertising board that a beer bottle bearing the brand was placed among the decorative elements included in the studio. The label was clearly readable, so the brand was visible. Additionally, in addition to the actual brand visible on the bottle, the alibi branding sign of the alcohol company, alcohol brand, which is +1, which is seen on the screen now. It was placed on the upright corner of the screen during the video. So the board, advertising board, held that this is a violation of the ban and advertising principles. And the second decision is about a social media influencer and its direct advertising of an alcohol brand, a tequila brand, which is Casamigos. The event was not held in Turkey. It was held, I guess, in Mexico. She claimed that it wasn't conducted, that she shared posts and videos on her Instagram as the first step to explain you. She claimed that it's a weekend event organized by the company, by the brand, and she claimed it as an invite without involving any promotional intention. But the advertising board surely was not convinced. The board ruled that this is a type of typical advertising since she shared posts and videos about the brand visible in his content. So the board ruled for sanction and issued an administrative fine. Yeah, that's everything from me. Thank you.
I wonder if that last influencer took the voluntary certification program. That was my thought when you were reading that one. But thank you. Very interesting presentation. And last but not least, we'll turn to Kanu to speak about India.
Hello everyone. In recent years, India has seen a significant evolution in its advertising regulations, driven by both statutory laws and self-regulatory guidelines. There has been a shift towards greater transparency in ads, increased accountability for advertisers and endorsers, and stronger consumer protection. So the main intention behind all these changes is that the consumers should be safeguarded from false claims and deceptive practices, and the government intends to align the regulatory framework with global standards and consumer-centric practices. Uh, the Central Consumer Protection Authority, which has been established under the Consumer Protection Act, has been highly active in reinforcing consumer rights since its inception. They have issued numerous advisories and guidelines in past 2 years, including the guidelines for prevention and regulation of dark patterns and guidelines for prevention of misleading ads. These initiatives all focus on combating the threat of misleading ads and holding both advertisers and endorsers accountable. A key aspect is ensuring that celebrities, influencers, and virtual influencers on social media platforms disclose material connections and exercise due diligence in substantiating their claims. The primary goal of these guidelines is to reduce misleading ads and enforce accountability, particularly in sensitive sectors like food and health, where misinformation can have serious consequences. Alongside the development of these regulations, the CCPA and the Advertising Standards Council of India have actively enforced compliance. ASCI is in fact monitoring both traditional and digital media closely to identify and address misleading ads. Between April and September of 2024, ASCI scrutinized over 3,000 ads for potential violation of its code, with 90% of these cases identified through proactive monitoring. Uh, in a in order to strengthen enforcement, CCPA and ASCI have collaborated this year, and CCPA has requested ASCI to forward any ad that violates their code and could potentially breach the Consumer Protection Act to them, and then these cases would be handled by CCPA. The latest development in India's push for transparency and greater accountability in advertising is the introduction of green guidelines by both ASCI and CCPA. These are long-awaited guidelines, and both ASCI and CCPA introduced these guidelines this year. These guidelines represent a critical step in ensuring that advertisers and endorsers adhere to ethical practices, contributing to a more responsible and consumer-friendly advertising landscape. ASCI's green guidelines apply to all environmental claims, suggesting or creating an impression that a product and/or its packaging or a service as a whole has neutral or positive impact on the environment, or has specific environmental benefits, or is comparably less damaging to the environment than a previous version or competing goods or services. All aspects of these claims would be relevant, including the meaning of terms that may be used, any qualifications and explanations, colors, pictures, logos which are being used, and the overall presentation. In the next slide, some of the important guidelines have been discussed. So basically, one of the most important guideline was that absolute claim like environment friendly, eco-friendly, sustainable, planet friendly must be capable of being substantiated by robust data, and they cannot be diluted by means of disclaimer or other clarificatory mechanism like QR code or website link. And the comparative claims like greener or friendlier over previous version or competitor's product, they need supporting evidence and basis of comparison. In the next slide, other important guidelines are given. So basically, aspirational claims about future environmental objectives should not be made in absence of clear and actionable plans. And if carbon offset does not occur within next 2 years, the advertisers should disclose that fact. And for specific claims pertaining to the product being biodegradable, recyclable, non-toxic, etc., the advertisers must qualify the aspects to which such claims are being attributed and the extent of the claims. All such claims should have competent and reliable scientific evidence to show that the product or the qualified component will break down within a reasonably short period of time after customary disposal, and that the product is free of elements that can lead to environmental hazards. CCPA, in the next slide, we are discussing CCPA's guidelines. Following ASCI, CCPA has also released guidelines for prevention and regulation of greenwashing. And as you can see, the environmental claim has been defined. So and greenwashing has also been defined in the next slide. So basically, it has been clarified that greenwashing does not include the use of obvious hyperboles, puffery, or the use of generic color schemes or pictures which do not amount to deceptive or misleading practice, or a company's mission statement that is not specific to any product or service. The guidelines have put a lot of emphasis on substantiation of claims. In the next slide. So basically, generic terms such as green, eco-friendly, good for the planet, regenerative, or other similar claims, they have to be used with adequate, accurate, and accessible qualifiers and substantiation. And if you're using technical terms like environmental impact assessment, greenhouse gas emissions, ecological footprint, consumer-friendly language has to be used, and the meaning or implication of technical terms has to be explained, which the ordinary public may not know. Guidelines also require that all environmental claims must be supported by accessible and verifiable evidence based on independent studies or third-party certifications. Next slide, please. The disclosures made in relation to the environmental claim should be easily accessible to the consumer and should not contradict the claim itself. And all material information should be disclosed either by inserting a QR code or a URL or using any other mechanism. Another important point is that we should not just highlight the favorable observations and obscure the unfavorable ones. All true observations should be highlighted, and specific environmental claims must be supported by scientific evidence and statutory or independent third-party verification. Next slide, please. Department of Pharmaceuticals under Ministry of Chemicals and Fertilizers and of the Government of India has also issued uniform codes for both pharmaceutical marketing practices and for marketing practices in medical devices. These uniform codes requires that the promotion of a drug be consistent with the term of its marketing approval. And in the next slide, the Uniform Code for Marketing Practices in Medical Devices specify that medical device must not be promoted prior to receipt of the product approval by the regulatory authority authorizing its sale or distribution. So both these guidelines require information about products to be up to date and verifiable. There should not be any misleading information. Next slide, please. One of the most important development of this year was this landmark case of Indian Medical Association versus Union of India. Patanjali Ayurved, which is an Indian multinational conglomerate, was publishing misleading ads with claims of curing diseases with Ayurvedic products during the COVID pandemic. They were disparaging allopathic medicines, and a writ petition was filed against them. So Honorable Supreme Court, via its order dated May 7th, held that advertisers, advertising agencies, and endorsers are equally responsible for issuing false and misleading ads. Endorsements that are routinely made by public figures, influencers, celebrities, they go a long way in promoting a product. It is imperative for them to act with a sense of responsibility when endorsing any product and take responsibility for the same. So court mandated submission of a self-declaration certificate regarding compliance of relevant laws and regulations before publishing or broadcasting any ad. Pursuant to the direction of the Honorable Supreme Court, Ministry of Information and Broadcasting issued a notification that all advertisers and advertising agencies must submit a self-declaration certificate before publishing or broadcasting any ad. This self-declaration certificate is to certify that the ad does not contain misleading claims and complies with all relevant regulatory guidelines. Next slide, please. The MIB's notification triggered significant panic among stakeholders, particularly due to the ambiguity surrounding the process for uploading the self-declaration certificate. Following requests from the prominent stakeholders to reconsider the mandate, MIB issued a new advisory that superseded the previous ones. This new advisory clarified that advertisers, advertising agencies issuing ads for product and services related to only food and health sectors are required to upload an annual self-declaration certificate instead of self-declaration certificate at the time of each ad. So they are only required to upload an annual self-declaration certificate. That's it for India. Thank you.
Thanks, Kanu. Very interesting to hear about the certifications and how those are kind of happening at the same time as making ads in India. So thank you for that. I'll just mention very quickly, please feel free to go to the website if you'd like to see some of our blogs or other updates as the year goes by with respect to advertising across the world. I hope everyone has a great December and a new year. And if you have any questions, feel free to reach out directly to any of our speakers. And thank you for attending today.